All right, I'm John Sluter, and this is the third segment of Plan 4 on the subject of crimes against peace officers in criminal courts. And I was reading today about at least one segment of the British Army having a motto: train hard, fight easy. The more prepared you are, or your attorney is going to trial, the easier the trial is. And there are some basic things you have to do. In California, which is where I practice, there's a thing called a Pitchess motion, named after Peter Pitchess, who was a old-time sheriff in Los Angeles County. And what a Pitchess motion is a way to get into the officer's personnel file and find out if people have made complaints about him for doing the kind of thing that you contend that the officer did to you, using excessive force, making false arrests, making arrests and concealing evidence. People have the right to file complaints, and under the law, when a complaint is made against a peace officer, the department is required to investigate it. Now, I'm not saying they investigate them real carefully, and I'm not saying they don't give the officer the benefit of every possible doubt. I'm not saying that they don't protect the officer if he seems to be racking up a large number of these. That's rare for the officers to get a whole lot, but they do. If an officer has a lot of them, then you're dealing probably with a pretty bad officer. The procedure of a Pitchess motion is, first, you have to present the legal authority for it, and you have to submit a declaration. Usually it's best for the lawyer to submit the declaration about what he thinks there is and why what he's looking for relates to some defense in your case. The California Supreme Court says that you don't have to, it should be a fairly low threshold of proof that's required. Some judges follow that. Other judges do feel that anytime somebody goes into an officer's personnel record, it is a violation of that officer's right to privacy and could be personally embarrassing to that officer. In federal court, where I do some action, like in the last segment I talked about a guy being my client but not being my client, I actually represented him on the civil case after charges were dismissed. But anyway, in federal court, the court seemed to feel like the officer's potential embarrassment about somebody looking at his personnel file about people who've complained about his on-duty conduct is relatively unimportant compared to a person's right to a fair trial. And the California Supreme Court seems to tip the scales like that. Some judges are more protective than, in my opinion, the law permits. But then nobody ever thought that I was smart enough to be a judge. So anyway, so a declaration is made, and if it's sufficient to show a credible alternative scenario to what's in the police reports, and the police reports have to be attached. A lot of lawyers forget that, but you have to attach the police reports. But if there's a credible alternate scenario, the judge should then do what's called an in-camera review of the police reports. In other words, she goes back into her or his office with a court reporter and the city attorney or county counsel and a representative of the police department, and she, page by page, goes through the part of the personnel file that talks about complaints against the officer. And if there's something that he or she thinks credibly shows some prior bad conduct that relates to your case, then she can order and should order, is required to order, that disclosed. Now, there are a few nuances. The statute concerning this in the evidence code says that the judge can only go back 5 years, but there's Supreme Court authority that says, well, if there's stuff that's necessary to the defense, then the judge has to disclose it even if it's more than 5 years old. Anyway, and then it's disclosed. You can your lawyer has the opportunity to contact the witnesses who are disclosed, and they may become part of your defense. So that's one thing you can do. Most lawyers know to do that. Most lawyers who regularly practice criminal law, but there are some other things you can do too. Sometimes people don't make complaints directly to the police department because they figure, why bother? It's going to be not well investigated anyway. What's in it for me? But, that sort of motive of what's in it for me sometimes does make people complain, but they use a different avenue. They actually file tort claims. Under California law, if you consult a lawyer, you'll find out that in order to sue a police officer for state law claims, it doesn't matter for federal laws, but for state law claims, you have to file a claim with the county or the city that hires the officer. Give them certain information germane to a potential lawsuit. And sometimes you can get more information there through a California Public Records Act request, or even by bringing a motion in court than you can through Pitchess discovery, which is somewhat limited and circumscribed. So you need to do a Pitchess motion, you need to do a California Public Records Act request, or a motion to get those tort claims that a person files because they're required to in order to bring a subsequent lawsuit. Some courts have searchable databases. Federal courts do. The county that I'm in does. But not really for the names of officers. So if you want to find out if an officer's been sued, you can go to the federal court database and you can run their name and you can see, have they been a defendant? It's another source of information about possible misconduct by them.